All right, I think we'll go ahead and get started. Good morning, everyone. Thank you for joining us today for a third in a series of workshops that SCAG is hosting along with the consultant team that you'll meet today. The topic for today's workshop is CEQA streamlining. And my name is Nasha Lalani. I'm an associate regional planner with SCAG and the project manager overseeing this project. And as you'll see on the next slide, this project is funded by SCAG as part of the Regional Early Action Program grant that we received and managed through the state. And I will give you a brief overview of our project progress to date. So if you'll take a look at our website, if you get a chance to go there, we have published a series of development streamlining materials and PDFs that you can look at your convenience. That includes, an overview of some of the topics that you may hear today. So please go ahead and take a look at our website if you want to learn more. There will be some time at the end for question and answer, so you can, of course, use that as an opportunity, but these resources are available to you and published on our website. In addition, you can also find past recordings of the 2 prior workshops that we held for this project on our website, along with the associated materials. Today's workshop is also being recorded and will shortly be posted on our website for you to access as well. And lastly, before I turn it over to the consultant team, I just want to highlight that the purpose of all the material that we're sharing today, as well as the materials that are available on our website, are solely for the guidance only. We request that all entities, participating use their own decision-making, whether they're at the jurisdiction level or maybe at the consultant level, to review any other CEQA or government-related requirements that may apply to their specific projects that they are pursuing. So with that, I will turn it over to the consultant team.
Thank you, Nasha. Welcome, everybody. I am Chad Beckstrom. I'm a Senior Environmental Director with Ascent and have been the project manager on behalf of SCAG for these development streamlining efforts. I'm happy to have Curtis Alling and Margaret Sahagi as my co-presenters here today. Curtis is a principal and co-founder of Ascent and is a recognized expert in complex and often litigious environmental impact and natural resource management programs. And Margaret is a managing partner of the Sahagi Law Group and has practiced for the last 30 years with a focus on assisting cities, counties, and other public agencies navigate the legal complexities of land use, CEQA, and NEPA. And prior to becoming a lawyer, Margaret worked as a city planner, so she's a planner turned lawyer. Before we begin, I just want to let you know about the next scheduled webinar. Today, we'll really be providing an overview of CEQA streamlining, focusing really more on exemptions. Webinar number 4 will focus more on tiering and streamlining housing approvals using prior environmental documents. That will be held on June 20th at 11:30, and you can register on SCAG's website shown here. A few housekeeping items to cover before we start. This webinar will be recorded and will be available on SCAG's website, so you can keep an eye out there over the next week or 2 before it's posted. If you have any questions along the way, please use the Q&A feature, and we'll attempt to address as many questions as we can at the end of the presentation. You're also welcome to send any questions you have to Nasha Leilani at her email address here anytime. We also will be hosting some office hours in the future to address more focused questions, so keep an eye out for those announcements and registration information. So our agenda for today, we'll start with an overview of CEQA streamlining, what it entails, and hopefully demystify some of what that means. We'll go over some of the traditional CEQA streamlining approaches. There are several commonly used exemptions and traditional tiering streamlining strategies we'll discuss, as well as a number of less commonly known exemptions that have been in the Public Resources Code and the guidelines for years. There are also several CEQA exemptions that have been adopted by legislation that have made their way into the Public Resources Code and the guidelines that are a bit more elusive. And then we'll show you some of the worksheets and tools that we've developed as part of the guidance materials to help you make the determination on which exemptions may be most applicable for your needs, and finally wrap up with a little Q&A. First, we'd like to start with a little poll, though. We'd like to know what type of CEQA document you most commonly use for housing approvals in your jurisdiction. So are most of you using, are most of you approving them ministerially, meaning no CEQA is involved because they're by right? Do you use statutory or categorical exemptions, perhaps Many are approved with neg decks or MNDs, or perhaps you need to prepare full EIRs. You may be using subsequent supplemental or addendums because your projects are within the scope of another environmental document. Or some of you even using the streamlining tools offered in SB 375 and SB 743. So I'll give you just a little minute here. All right, do we have the results, Jamie? All right, so it looks like over half of you are using categorical statutory exemptions with neg decks and mitigated neg decks coming in about 30%, and EIR is kind of rounding that out. So looks like some of you are taking advantage of some of the streamlining, at least for some of the exemptions here, but hopefully we'll open up your repertoire here. Okay. So what is CEQA streamlining? I think we all know that California is facing a severe housing shortage. CEQA compliance should be as efficient as streamlined as possible. It's particularly important for addressing the state's unmet needs for affordable housing. You know, the legislature has made several attempts to provide CEQA incentives in their bills to facilitate housing production, but with so many options and conflicting information, it just seems to get more complicated and harder to figure out which options are applicable. So streamlining is really not a loophole in its simplest form. Streamlining involves expediting CEQA review through an exemption or reliance on previously adopted environmental documents. These are generally designed to provide some incentives and relief for projects that have minimal or no impact on the environment, or that have been already addressed at a higher level to avoid having to repeat the CEQA process and prevent redundancies. Now, the best approach is really going to depend on the type of project, the location, and many other factors. And it's possible that some projects are eligible for multiple streamlining options. So what does streamlining look like? The first step would really be to look for exemptions. There are lots of these, some of which you may not be aware of that we'll talk about. And if the project cannot fit an exemption, next you'll look to see if there are other environmental documents that may be used to tier from. We'll be covering that more in the next webinar. And there are several options here as well. If your project is in an area that has access to transit, there are special considerations that may be available for streamlining. And with the complexities and varieties of exemptions, the decision is really becoming more and more difficult. It takes more time and effort. So hopefully getting a better understanding here can expand the tools that you have at your disposal. Okay, Curtis, you're going to be talking a little bit about the traditional streamlining.
Okay. Thank you very much, Chad. Good morning, everybody. Really appreciate you joining us here at our workshop today. As Chad alluded to, there are specialized bills that have set up exemptions specifically for different types of housing, but we wanted to start with what we like to call regular CEQA, where for years there have been different approaches for using exemptions and other tools to accelerate and expedite the CEQA process. So we'll cover some of those first today. This slide shows the list of the types of traditional CEQA approaches that we'll talk about: statutory exemptions, categorical exemptions, Article 12.5 exemptions that refers to an article of the guidelines that address some of the specialized housing exemptions, projects that are consistent with a specific plan, and use of prior EIRs prepared and whether there's need for subsequent supplemental or addenda, and tiering and program EIRs. Those last two subjects will be a part of our next workshop, so please stay tuned for those. We'll cover the other exemptions and consistency with specific plans today. All right, next slide. This all begins with the preliminary review period, which is what the guidelines reference below the photo is. That actually should be 15060, just as something to note in your notes. This preliminary review period is where you determine if the approval that you're seeking is indeed a project under CEQA, that it's a discretionary action by a public agency and it has the prospect of causing a physical change, or if it's not a project, such as a ministerial decision. Sometimes building codes are ministerial. In other words, if you check off the box of satisfying the specific requirements of the ordinance that you're dealing with, and there's no opportunity for discretion, then it can be ministerial, and therefore it's not subject to CEQA. And if there's no possibility at all of a physical change in the environment, then the project can be exempt from CEQA. That's sometimes called the common sense exemption. Next slide, please. Okay, categorical exceptions. There are 33 of those in the guidelines, and they cover all sorts of different situations where the expectation is, just because of the category of the project, the expectation is there wouldn't be substantial adverse impacts, significant impacts under CEQA. The classes of categorical exemptions that are applicable to additional housing supply are class 3 for new construction or conversion of small structures, and class 32 for infill projects in incorporated city limits. There are exceptions to the exemptions that one must cover. So that's one aspect of using any of the 33 categories of categorical exemption, and for some of the exceptions, and also the location of the project for certain of them, including the one we'll talk about for small structures. The exceptions include whether there's a cumulative impact, where this project in combination with others may result in a significant cumulative impact. There's whether there may be a reasonable expectation of a significant effect on the environment because of unusual circumstances, whether there's an adverse effect on scenic highway related to hazardous waste sites, or significant change, adverse change to historic resources.
Curtis, can I jump in here and
Absolutely, Margaret, please do.
Tell us a story? So years ago, I received a phone call from a client who was exploring the use of a class 3 exemption. I think it was the commercial less than 10,000 square feet that falls within class 3. And these are all questions we have, right? You open up your CEQA guidelines and you start shopping for an exemption. So we had the conversation back and forth about the class 3, and I was pretty happy that the client was able to check all the boxes for class 3 exemption for the project. And then I just said to, let's call her Patricia, I said to Patricia, well, you aren't on any Cortese list hazardous waste site, are you, by chance? Because I'm thinking about this city. And she goes, well, yes, we're on a Superfund site. So you were nixed from using that categorical exemption. And it was something that Patricia had never thought about. And it's a question one always has to ask. And I think this is the most common conversation I have back and forth with clients. What exceptions can we use? And then they always forget about the exceptions. It's because it's just not logical. So this is just to highlight the need to go through this list that Curtis has been discussing. And a side comment here as well, as Curtis said, we're focusing on the exemptions that relate to housing. There are lots of others. There are many exemptions that are outside CEQA as well. So you have to be looking through other code sections. So I noticed OPR has a great technical advisory, albeit 5 years old at this point, that lists the exemptions that are outside of the CEQA code, things in the water code, fish and game code, and the like. So that's a tangent. We're focusing on housing today, but I think you need to be aware that there is life beyond CEQA here. So
yeah, thank you. And it mentioned on the previous slide, those exceptions are in 15300.2 if you want to look at how specifically they're worded. So Margaret, on to you.
thank you. Curtis mentioned one of the important exemptions that seems the last several years, decade, has really been a focus of litigation. So we wanted to highlight it here today. And this is the unusual circumstances exemption. The standard of review related to this exemption went up to the California Supreme Court in Berkeley Hillside Preservation versus the City of Berkeley. And the question was, how do you review this? Most categorical exemptions are subject to a substantial evidence test, but this is the exception to the exemption. So the court laid out two different tests for how you figure this out and what is the standard of review. It's all somewhat convoluted in my opinion. And so we asked, of course, is the Supreme Court going to be clarifying this? So you can decide if it's clarified for you, but at least we have a legal standard or two here. So the first way you address this unusual circumstance is you look to see if the unusual circumstance applies when it can be shown that first, the unusual circumstances are present, and second, that these circumstances lead to a reasonable possibility the project could result in a significant impact. So that's two prongs as you see on this slide. So that's when the exception is triggered. And that first prong is a substantial evidence test. Can you say as a lead agency that unusual circumstances don't apply and you've got the substantial evidence to support it? However, once you've found that the unusual circumstance does exist, if you find that, you go to that second prong and you ask if there's substantial evidence to support a fair argument that the significant impact might occur as a result of the unusual circumstance. In that case, you cannot use this exception you can't use the exemption because of this exception. Now, the Supreme Court went on just to confuse you a little bit more and added a second test that knocks you out of the box. And that only asks one question. That says if the agency finds that the project will have a significant effect and that finding establishes that some of the circumstances are unusual, then no categorical exemption can be used here. Okay, you've gotten all the legal jargon here. Let me try to give you a couple examples. Take the Berkeley case. So Berkeley was a 10,000 square foot home on the Berkeley hillsides. That established this test. The case on the facts went back down below, and the court said that petitioners did not even establish that there were unusual circumstances, that the slope and the side and all of the issues, the scale of the project were not unusual. Okay, so therefore, petitioners were knocked out of this box and a categorical exemption was appropriate. There was a subsequent case called Walters versus the City of Redondo Beach, a 2016 case. And in that case, a class 3 exemption was being used by the city for a car wash and coffee shop. Here again, commercial, less than 10,000 square feet. Petitioners Walters argued, no, unusual circumstances exist, because this is going to be a big car wash with a big coffee shop and lots of machinery. But the city had done something very important in creating the record to use this class 3 exemption. They had put substantial evidence in the record as to why it was not an unusual circumstance. They had evidence of similarly situated car washes already in the record. In fact, there was a car wash within a minute's drive from the project site, 5 car washes within 2 miles, and 12 car washes within a 10-minute drive. And earlier, a couple decades earlier, the exact site had been a car wash. That is the kind of evidence a lead agency wants to put in the record for something like this. This is a very common exception to the exemptions that are used by petitioners. So here, of course, I'm speaking from the lead agency perspective. My clients think ahead about how this relates and what evidence you could put in the record. So next slide, and off to you, Curtis.
Okay, well, I must say it must be very nice to live in a neighborhood where a 10,000 square foot home is not an unusual circumstance. Okay, let's talk about class 3 a little bit more. This is the new construction or conversion of small structures exemption. It can be very useful if you have a project that is of the appropriate size to fit and qualify for this. Just paraphrasing, or actually not paraphrasing, excerpting pieces of the description of this class consists of construction and location of a limited number of new structures or conversion of existing small structures from one use to another, where only minor modifications are made to the exterior of the structure. So the list of examples are also described in this exemption as maximum allowable uses that could qualify. So they're actually a little bit more than just examples, as often is the case in our categorical exemptions. But they include one single family or 4 multifamily units in a structure that can go up to 3 single family or 6 multifamily in urbanized areas, and then up to 4 commercial structures of 2,500 square feet each, or a combination of up to 10,000 square feet. So as you can see, the opportunity for development that adds substantially to the housing supplies is modest here, but it certainly can fit the right kinds of parcels. Next slide. The approach slide here and the advantages and disadvantages are noted. It obviously avoids the need for another environmental document if you use this exemption, if your project qualifies. And if you have small parcels in a residentially owned area, then it can be useful, but it is limited to that circumstance in all likelihood. The approach is to document the reasons that it's consistent with the qualifications of this categorical exemption, consider the exceptions, and then to prepare a notice of exemption. Now, notice of exemption is not required, but we always recommend that the notice be filed so that you can take advantage of a 35-day statute of limitations period instead of what would happen if you didn't file, which could be for 6 months or 180 days. Okay, next slide. All right, the class 32 infill exemption is one of my favorite ones. And the reason it is it's pretty simple and pretty flexible as exemptions go in CEQA. It can be used only in city limits, incorporated cities, which is one of its shortcomings if you're in an urbanized, unincorporated area. But beyond that, the flexibilities are here as shown on the qualifications on the slide. It can be on a parcel. It's up to 5 acres, and in a multifamily housing circumstance, that can support a substantial number of units, and there is no maximum dwelling unit limit for this exemption. Needs to be surrounded by urban uses consistent with the general plan and zoning, served by utilities and public services, all the kinds of things that would occur, you'd expect to occur in most circumstances where you're proposing a residential project on 5 acres in an urban area. So those really don't cause many concerns, but environmental considerations need to be evaluated to a degree. There are some specific ones that I want to go to the next slide, Chad. There's some specific ones that are noted in the description of the categorical exemption, shown on the bottom half of the slide here, where there has to be no habitat value for the property, and have to be absence of traffic, noise, air quality, or water quality significant effect. So what happens in a practical way for this exemption is that we found that you need a small analysis, if you will, to demonstrate that your proposed project is consistent with the qualifications, including the absence of some of these environmental issues. But that can be pretty thin, pretty simple to do. And again, this is a very powerful tool we found in the past. Okay, next slide, please. All right, now we'd like to move to some of the other exemptions that have been adopted in statute for residential projects. This is one that also deals with an infill situation, if you will, but seeks to perhaps cure the limitation in the Class 32 infill exemption of only being in incorporated limits of a city. This exemption is in the statute in Public Resources Code 21159.25A, and it applies to unincorporated urban areas, and it also indicates that it can be a mixed use, not just a residential project, and the residential component of it has to be 2/3 of the project, square footage, and it has to be surrounded at least 3/4 of the way by qualifying urban uses, and also has some of the same environmental conditions requirements of the other exemption. Next slide, please. We can look at the approach. Advantage, like I mentioned, it can be used in urbanized, unincorporated areas, and it doesn't have to be 100% residential, which often might be the case for a project that is in an urban area where maybe the ground floor is retail, for instance, and the upper floors are residential. There are exceptions in the Public Resources Code that need to be addressed, and they may require some other technical studies or other documentation to do those. And those exceptions on the next slide. I think we've got those, right? No, we don't. Well, they're related to cumulative impact, significant impacts for unusual circumstances. These are very much like the exceptions to other categorical exemptions. Damage to scenic resources that are within the view of a scenic highway, the hazardous materials exception that Margaret talked about in her story, and significant change to historic. So
Curtis, I think it points out what we've been seeing in the last few years is you don't go to Sacramento and get a simple categorical exemption or even a simple statutory exemption anymore. And these are perfect examples that there's qualifications. And I think it's great that you've pointed out that you may need to do some early technical studies. So it's not something you look for at the last minute on the day that you're publishing your agenda packet. These require some forethought. And I think that's the trend that we're going to continue to see.
Mm-hmm. Absolutely. And that's why I like Class 32 so much, because by comparison, the technical analysis you have to do is pretty simplified. The exceptions are still there, but if you can address those in a skinny document, then that still can be very much of a useful approach. Okay, next slide, please. Now we're going to move to a different subject, and that is projects that are consistent with a specific plan for which an EIR has been prepared. This slide talks about residential projects implementing a specific plan, and also it makes reference to proximity to transit. And I wanted to note that the guidelines blend these two I'll call them types of exemptions for projects consistent with a specific plan. And they actually have separate statutory origins. There is an opportunity to find exempt a residential project that is consistent with a specific plan in the government code. This is one of those that you mentioned, Margaret, that's not in the Public Resources Code in 65457. And then there is a separate government or a separate statutory origin for the transit proximate projects in Public Resources Code 21155.4. This is part of SB 743 from 2013. I should say that the government code one goes all the way back to 2006. So it's been around for a very long time. All right, let's go to the approach slide, please, Chad. All right, so if a project is consistent with a specific plan and the project proposes residential uses, that specific plan has been prepared after 1980, which probably all specific plans are at this point, then if you demonstrate the consistency with a specific plan, and then you also demonstrate that there are no new significant impacts or substantially more severe significant impacts that were covered in the EIR for the specific plan. This is the the typical supplemental review questions in section 15162 through 15164 in the guidelines. Then you can demonstrate that, then you can take advantage of this exemption. And Margaret, I know there have been court cases that have, I'll say, validated the use of this before. I think the most recent one is came from Livermore this year, Save Livermore Downtown versus City of Livermore, regarding an affordable housing project. And there are other court cases as well.
Absolutely.
And so that's a powerful one, but you have to have a specific plan. You have to have invested in the specific plan and had the EIR. But after that, it's a very powerful exemption. Then the final one to mention is where a project is within a transit priority area, proximate to transit. And here you have to demonstrate the consistency with a specific plan, because there needs to be a specific plan for an EIR in this one too. You also have to demonstrate that it fits the criteria in 15182, which has the different distances from transit, and that it's consistent with the region's sustainable community strategy or alternative planning strategy. And then again, demonstrate there's no new significant effects or substantially more severe impacts. My question here, though, or I guess my editorial comment is that if you've got a specific plan with an EIR and a residential project that's consistent, and it's a simpler approach using the government code, why go through the trouble of the transit criteria as well? It certainly can work, but I think you can just follow the general or the generalized specific plan.
Curtis, I agree with you. Though in general, I'm a big fan. If more than one approach fits, use multiple approaches. If you never know when a court's going to ding you on one. So the more the merrier.
Good point. Chad, back to you.
All right. Thank you, Curtis. Yeah, I'd like to talk a little bit now about the Article 12.5 exemptions in the secret guidelines. Now, these exemptions were created for special housing circumstances to help streamline affordable housing, residential infill, and agricultural housing. And because of the limitations and conditions built into the statute, these are used pretty infrequently, but they are available for qualifying situations. So certainly wanted to bring those to your attention. Now, before any of those three exemptions can be used, there is a lengthy list of thresholds that must first be addressed. I'll save us the time of reading all these, but you can see many of these are similar to the criteria and the same exceptions for categorical exemptions, the class 32 exemptions, and the unincorporated infill exemptions. But there are a few new ones here that I wanted to point it out. For instance, community environmental review must be completed. So for instance, the general plan EIR, there must be a commitment to pay development fees. You must complete a preliminary health hazard assessment. There must be no wildland fire hazards, risk of explosions or seismic hazards. And I think while we should all know that piecemealing is not allowed under CEQA, this particular section explicitly prohibits project segmenting. So if you can meet all those thresholds in 15192 of the guidelines, this agricultural housing exemption allows for up to 45 units or group housing for up to 45 workers. There are restrictions on the size of the site to a maximum of 2 acres if, based on population density. So if the density is over 1,000 people per square mile, it's 2 acres, or 5 acres if the population density is less than 1,000 people per square mile. Now, there are also various criteria regarding location, whether the project's in city limits or another census-defined place with specific population densities, and the site must be adjacent to developed land on at least 2 sides. Now, what's interesting about this one is if the site is zoned for agriculture, you're only limited to a maximum of 20 units or group housing for 20 employees rather than the 45. There are also commitments here that are required to make housing available to lower income households for 15 years. And if there is public assistance provided, it must be available for very low, or moderate income for a period of 15 years. Next is the affordable housing exemption. Again, you first must meet all the thresholds and fulfill the criteria in 15192. Then you can consider this particular exemption for projects that have fewer than 100 units on 5 acres or less. There are also criteria regarding location that factor in the incorporation status, population density of the area, whether parcels were previously developed or are located adjacent to parcels developed with qualified urban uses. So you can find all of those details in the guidelines and Public Resources Code. The project must also be affordable to low-income households for 30 years at monthly cost deemed to be affordable rent to lower, very low, and extremely low income. There are also other multiple factors that get a bit more complex that must be considered. And again, I suggest consulting the guidelines for more details if you feel like you can meet some of these other criteria here. Now, the residential infill exemption is for projects with 100 units or less on 4 acres or less. The project site must be classified as an infill site and be within half a mile of a major transit stop. The project must also promote higher density infill. So what does that mean? That criteria can be established either by the lead agency, but for projects with at least 20 dwelling units per acre or projects with at least 10 dwelling units per acre that also have a density greater than the average of properties within 1,500 feet are automatically presumed to meet that definition of promoting higher density. Now, the project must be also made available to 10% moderate income, 10% low income, and 5% very low income, or the developer must pay in lieu fees that result in an equivalent number of units. There are some additional exceptions here that need to be accounted for beyond the threshold criteria, including whether there's a reasonable possibility of a significant impact due to unusual circumstances, whether there are substantial changes in circumstances that have occurred since the community level environmental review has been certified, and whether there's new information that arises regarding circumstances of the project since the community environmental review. It's similar to some of the criteria used in determining whether a supplemental or subsequent EIR may be prepared, but it's slightly different. So keep that in mind there. So we wanted to give you another poll here, or a quiz, if you will, in which we'll want to ask you which exemption or exemptions, there might be more than one, might apply here. So in this particular scenario, the project would involve 90 multifamily residential units on a 3.9 acre infill site surrounded by developed properties. The project's located within unincorporated city limits and is within half a mile of a transit stop. It's consistent with the general plan for which an EIR was recently completed. The developer is committed to providing 10% of the units for low income affordable housing for up to 30 years. And the site does not have environmental sensitivities or other impacts that are evident. So what do you think? Take a minute here to answer the poll. Need some Jeopardy music. All right.
Curtis, can you go back to the factual slide so people can compare? There you go. Thank you.
You bet. How are we coming along on answers, Jamie?
We've had 7 people complete it so far.
Okay, we'll give it another 10 seconds.
Just take a wild guess. These are difficult, but
We'll tell you the answers here in a second. All right, let's see the results. See what people think. Kind of a bit all over the board. Half of you think class 32. 25% of you think maybe the mixed use and unincorporated areas. 25% think affordable housing, Article 12.5, and 63% think residential infill. So let's see. So here's our thoughts on this. The project has too many units for class 3. I think that one's fairly obvious. Class 32 does not have density requirements nor limitations on the number of units and does not have affordability requirements. The residential or mixed use housing pursuant to the 21159.25 is limited to unincorporated areas, whereas class 32 is for incorporated cities. So I think that one did not apply. Now, the affordable housing exemption in Article 12.5 requires commitments for all units to be lower income, very low income, and extremely low income. So offering just the 10% was not enough to fulfill the requirements there. Whereas the residential infill in Article 12.5 requires not less than 10% for low income families or payment of in lieu fees. So we think class 32 and the residential infill are the most fit that particular scenario the best. Okay, Margaret, you'll talk a little bit here.
We're going to change courses here a little bit and talk about tiering. Go over this generally because tiering can result in sort of less time intensive, which of course is something that we're all looking for in the CEQA review for housing projects, and the legislature is certainly supported of that. So the question is really, what do we mean by tiering? And tiering definitely refers to using an analysis of general matters contained in a broader EIR. I always think of a general plan EIR or something similar, with later EIRs or even a mitigated negative declaration focusing on the more narrow project. If you are not familiar with tiering, please look up the guidance in CEQA guidelines, section 15152, as well as Appendix J, which gives some examples. And as Curtis and Chad both mentioned earlier, we're going to go into streamlining and tiering in greater detail on June 20th. But other examples here that you'll see listed in 15152 would be a program EIR, and then later actions tiering from that program EIR, later actions tiering from a master EIR, not a type of EIR often used, subsequent or supplemental review that's allowed for under CEQA, or a project that's consistent with the general plan or zoning ordinance. These are examples of tiering. Infill projects that are consistent with a sustainable community strategy, or an EIR for a planning action. So tiering is really an excellent tool if you're getting beyond the categorical exemption checklist. So the tiered document, that second tiered document, would incorporate by reference the general discussions from the first tier document, and then concentrate, as I said, on your second tier to the more specific matters of your project. Again, take a look at Appendix J to get some ideas and approaches that you can use. Next slide, please. So here's one type of first tier document when we're talking about tiering, and that would be a program EIR. Very effective tools that I'm seeing my clients use effectively to accelerate housing development. So the program EIR process, and we noted on this slide here, is set forth in 15168. It involves preparing a comprehensive EIR. This is nothing short and easy. It's a full-blown EIR on a series of actions that could be characterized as one large project. So one example would be a specific plan EIR, perhaps, or affordable housing development. And then again, that later document would incorporate by reference the general discussions from this programmatic EIR. And you'll see listed here the types of programmatic EIRs. I mentioned specific plan EIR. That's typically a geographically defined programmatic EIR. You could have several parts of a project together. You could have individual activities with the same lead agency with similar effects and mitigation. So that sometimes involves different applicants, which in my experience can also be a little bit challenging when working as the lead agency on preparing that EIR. You've got different applicants with different mindsets and projects. Next slide, please. So another type of tiering involves a subsequent supplemental EIR or an addenda. So anytime you have a further discretionary approval by a lead agency or a responsible agency, could be a responsible agency, that's required for a project for which you already have an EIR or a negative declaration that's been certified or adopted, you need to ask whether anything is triggering with this discretionary action the need for a subsequent or supplemental EIR. Now, this is an interesting section of CEQA to me, because it's the only section that includes a presumption against requiring further review. I mean, it says in 21166 and 15162 that once a lead agency certifies an EIR and approves a project, no subsequent EIR shall be prepared unless the lead agency determines in that instance, based on substantial evidence, that there's what? 1, substantial changes to the project, or 2, substantial changes in circumstances, or there's new information that could not have been known at the time the EIR was certified that becomes available, and that information would require major revisions due to new significant impacts or more severe significant impacts. Okay, so the streamlining occurs when you're limiting the scope of this second tier document. Now, if you go through this checklist and you find that you're not triggering any of these 3 changes, then you use an addendum, and that will justify and help you put the substantial evidence on the record to show that an addendum is appropriate. And I use something that I call a revised initial study that asks these 3 bulleted questions along the x-axis and go through each of the resource areas just to make sure that there haven't been substantial changes to the projects or changes in circumstances. Next slide, please.
All right.
Right.
Thank you, Margaret.
Uh-huh.
So next we'll cover some of the exemptions provided in SB 375, SB 226, and SB 743. But we're going to start with another poll. I want to find out from you, before we get into some of these issues, what is your biggest constraint to using some of the CEQA streamlining tools? Do you fear legal challenge? Is it a lack of knowledge or understanding by staff or decision makers? Do you lack the resources that may be necessary to implement some of these tools? Have you found these streamlining tools have not worked for you? Maybe you've tried them. Or are you using these with overwhelming success? Let's hear a little bit from you all. All right, let's see the results there. Okay, so about a quarter of you are fearing some potential legal challenge. Over half of you, maybe a little lack of knowledge or experience. So hopefully this webinar will be helping you with some of that. Maybe some of your decision makers have different expectations. Some of you, small amount of you chose that one. And then certainly lack of resources. We've heard that over and over from time to time. So, all right, thank you. Let's move on. All right, so SB 375 was adopted with the primary objective of achieving greenhouse gas reductions consistent with AB 32 through regional transportation planning. Now, it does offer some CEQA incentives to projects that are consistent with a sustainable community strategy. And so CEQA was amended to add a sustainable communities project exemption for transit priority projects, or TPPs as we call them. And for those transportation priority projects that do not fit the exemption, there are other options for streamlining using a sustainable communities environmental assessment, or a SCIA, as we've sometimes heard it called, a limited EIR, or reduced level analysis. And for those later options, we'll get into more of those in the next webinar, but want to focus today more on the exemption. So the sustainable communities exemption applies to projects with no more than 200 units on less than 8 acres within a half a mile from rail stops or a quarter mile from a high quality transit corridor. There are some specific definitions of those in the guidelines, so certainly you'll want to consult that just to make sure if you're within those areas. Now, at least 50% of the project must be residential with a minimum density of 20 dwelling units per acre. And if the remaining portion is non-residential, there must be, it must have a floor area ratio of at least 0.75. Now, in order to be applicable for this particular exemption, there are 8 environmental and 7 land use criteria that must be met. I'm not going to list them all here, but many are very similar to some of those we discussed in the other exemptions. A few notable differences, though, or new ones, is that the buildings must be 15% or more energy efficient than Title 24, and they must achieve 25% less water usage than the average household in the region. There also must be no net loss of affordable housing, and the project cannot conflict with nearby industrial uses. The project also must provide at least one of 3 community benefits. So you have your choice here. You can provide affordable housing at 20% moderate, 10% low, or 5% very low for a period of 55 years for rentals or 30 years for sale units. You can pay in lieu fees, or you can provide 5 acres of open space per 1,000 residents of the project. Now, the project may be found exempt after holding a public hearing, declaring it a sustainable communities project. So when considering this exemption, there are some additional things you'll need to consider. The statute does have a rather strict definition of transit priority projects, and there are, as I mentioned, numerous environmental land use and community benefit criteria that must be met. But if you feel you can meet the eligibility standards, you would hold a public hearing, declare the project a sustainable communities project backed by substantial evidence that it meets the criteria, and then file a notice of exemption, as we recommend for any of these exemptions that you intend to use here. Now, in the context of the Sustainable Communities exemption, we want to provide a little background on SCAG's Sustainable Community Strategy. SCAG's SCS is combined with the Regional Transportation Plan, which provides a vision for Southern California's future, as well as policies, strategies, and specific projects for advancing the region's mobility, economy, and sustainability for at least the next 20 years. Now, the plan, it integrates regional development patterns and transportation networks and identifies strategies that achieve greenhouse gas reduction targets that are pursuant to SB 375 requirements. The current 2020 RTP SES, also known as Connect SoCal 2020, was adopted in September 2020, but the plan does need to be updated every 4 years for federal requirements. So SCAG is currently developing the Connect SoCal 2024, currently underway. And for more information, you can visit this website here, which we'll add into the chat. So you'll have that link at your disposal. Okay, for SB 226, SB 226 was adopted with the intent of promoting faster and simpler approval of infill projects that are consistent with the sustainable community strategy. Section 15183.3 of the guidelines was added, which allows for limited CEQA review for certain infill projects through, through a process that resembles tiering of EIRs. These provisions limit CEQA review to those effects that were either not addressed in a prior EIR or general plan, community plan, specific plan, or zoning, or to the effects associated with substantial new information where impacts will be more significant than in the prior EIR. Now, these provisions apply to a wide range of project types, including residential, retail, commercial, or mixed-use development, transit stations, schools, and public office buildings. The site must be within an urban area that's been previously developed, or at least 75% of the perimeter adjoins existing qualified urban uses. And there are standards outlined in Appendix M of the CEQA guidelines that must be met. And these include things like design elements such as renewable energy, soil and water remediation, and making sure the site is 500 feet or more away from high volume roadways and stationary sources. There are also additional standards in Appendix M based on the project type. So for instance, residential projects must be within low vehicle travel areas and achieve below average regional VMT. They must be located within a half a mile of a major transit stop or high quality transit corridor. And there must be a commitment to lower income affordability. And the project needs to be consistent with a sustainable community strategy or alternative planning strategy. So while this does apply to a wide range of projects, it does require some level of documentation. But after completing the documentation, you could be rewarded with a no further review determination, which is not an exemption per se, but in practice, it's like an exemption. So we certainly wanted to include that here in this presentation today. But first, you will need to complete a written checklist. Appendix N of the CEQA guidelines provides a sample checklist that may be used. You'll see some subtle differences from Appendix G. It's essentially a modified Appendix G checklist. You'll want to explain whether any effects were analyzed in the prior EIR and incorporate applicable mitigation measures. You'll want to explain whether there are new effects that were not addressed or substantial new information shows adverse effects are more significant. And you'll want to indicate whether there are uniformly applicable development policies or standards, which we call UADPs, that may substantially mitigate significant impacts. So what are these UADPs? These may include things like parking ordinances, grading ordinances, hillside ordinances, habitat protection, view ordinances, things of that nature that, that you can apply to mitigate or substantially mitigate those potential environmental effects. So a no further review determination may be made if the project results in no new specific effects or more significant effects, or there are those UADPs that substantially mitigate those effects. Otherwise, you may need to prepare a neg deck, MND, or infill EIR. Either way, one of the benefits here, or the streamlining benefits, is that your analysis is not required to address growth-inducing impacts, or analysis of alternatives does not need to address alternative locations, densities, or building intensities. Okay, on to SB 743. So 743 was adopted with the purpose of fostering land use changes that would encourage less driving. So for example, mixed use and transit-oriented infill projects. This law too established CEQA streamlining incentives for projects that are consistent with an SCS by adding sections to the public resources code and the guidelines for transit-oriented development that's consistent with and implements a specific plan for which an EIR has been certified. Now, Curtis touched a little bit on this earlier in one of his slides, but noting that SB 743 also established that aesthetic and parking impacts are not considered significant for qualifying projects, except where there may be historic resources that could be affected. So this exemption, as I mentioned, is partly similar to the CEQA guidelines 15152 for projects pursuant to a specific plan. Now, in order to qualify for this exemption, a project must be residential, mixed use, or employment center. It must be an infill site within a transit priority area located within half a mile of transit. And like many of the other exemptions, this project must be consistent with the sustainable community strategy. If there are substantial changes or significant new impacts relative to the specific plan EIR, then the project is not eligible for this exemption. So you'll need to consider the triggers for supplemental, subsequent, and addenda based on changes to the project since the specific plan EIR has been adopted. So some of the advantages to using this provision, a variety of uses are eligible. There are no number or no limits on the number of units, building floor area, or the size of the site. There are also no stated environmental restrictions like there are with some of the other exemptions. And as far as the approach, you'll want to first demonstrate consistency with the sustainable community strategy or alternative planning strategy. You'll want to document any changes to the specific plan CEQA document. We suggest using a modified environmental checklist like you might use for an addendum. And as I mentioned, you may omit aesthetic and parking impact analysis or conclude that they're less than significant. So time for another quick quiz here. Want to give you another scenario here. For this project, you, as a lead agency, may be processing an application for 140 multifamily units on a 6.9 acre infill site surrounded by developed properties. The project is located within unincorporated city limits within a quarter mile of high quality transit corridor. It is consistent with a sustainable community strategy as well as general plan and a specific plan for which an EIR was completed recently in 2021. The developer is also committed to paying in lieu fees for affordable requirements, and there are no apparent environmental sensitivities or impacts. So which one or which, there may be more than one here, which one of these exemptions do you feel applies? Give you 30 seconds here. And feel free to take a guess.
We have about 40% participation.
All right, let's see the results. All right, kind of all over the board. I think it looks like 90% of you feel the transit-oriented mixed-use exemption would apply. Another 80% feel the sustainable communities exemption would apply. Half of you feel residential infill in Article 12.5, 20% affordable housing in Article 12.5, and 30% Class 32. So let's see what we think here. Okay, so the site is too large for Class 32, which is limited to 5 acres, and this site is 6.9 acres. So we did maybe try to trick you guys a little bit here. Residential infill, Article 12.5, is limited to 4 acres. The affordable housing, Article 12.5, requires low-income commitments for all units. This does, however, appear to be eligible for the sustainable communities exemption, as well as the transit-oriented exemption that implements a specific plan. I think the majority of you seem to get those two there. All right. So before we end here, I did want to do a little show and tell with some of the guidance materials and the worksheets. Nasha showed a slide earlier of the SCAG's website, and I just wanted to highlight a few of those, a few of these for you and give you a little tour. So each of the guidance materials, they're relatively short. They provide some overview of the different, this one is particularly regarding categorical exemptions, gives a little overview, some tips and tricks. And I think one thing that may be most helpful for you is there are some worksheets here in the back of these, which walk through the different requirements, the applicability. We do have some links here that might help you determine whether or not your project would be eligible under each of these specific criteria. So we have that for categorical exemptions. We also have one for all of the Article 12.5 exemptions, including the affordable housing, residential infill. Again, there are worksheets here in the back for you. We have one that combines the sustainable communities exemption and the transit priority exemption. So again, some worksheets. I know that might be a little dizzying going through these rather quickly. And I think one thing that might be most helpful is we've prepared a matrix here, which is allows you to sort of do some comparisons at a glance, where you can kind of see what the different housing types, what the applicability requirements are, what it must be consistent with, site requirements, the site size, whether there are any location restrictions, and what might kick you out of using one of these exemptions. So these are all available to you on SCAG's website here. Again, scag.ca.gov/streamlining. And, oh, okay, we'll finish with a poll here. So we hope that, that this has expanded some possibilities to streamline SQL reviews. So I want to provide this final poll to gauge whether you would be more likely to use some of these in the future. Just let us know what you think. And with that, we can open it up to some Q&A here. And at the moment, I only see one. Let's see. If a potential housing development is not seeking a general plan amendment or zone change on a parcel, can the city still require a complete EIR?
And why don't I jump in? I'm also a partner with Sahagi Law Group. So as all lawyers like to give, the answer is it depends, but we'll give you a little bit more than that. I think with this type of question, you're first going to be looking at whether there are any applicable exemptions, whether statutory or categorical. But from a purely CEQA perspective, general plan and zoning changes are not the only triggers for environmental review. You can have things like conditional use permits or other types of discretionary permits. But housing projects unto themselves are not considered expressly exempt from environmental review. And you have language stating as much under the Housing Accountability Act under Government Code 65589.5 subsection E. That says that housing projects are still subject to CEQA, at least as a matter of law, if you ignore the various exemptions. I think there's likely a line of cases that are going to slowly become created about whether you really have any remaining discretion, because the Housing Accountability Act says that you as a public agency don't have the ability to deny or reduce density unless you can meet some express categories of findings. And I think we're going to start to see residential projects come forward where you really don't have much remaining discretion. So a project may come in and want to build over every square inch of the parcel. So you wouldn't normally have your conditional use criteria that allow you to move the project within the boundaries of the parcel at issue. And there is a narrow line of CEQA cases that I think we'll see continue to expand, and I call it McGorkle, after the case from several years ago. And that case talked about a scenario where arguably the public agency did have a discretionary approval, but the discretion that it had didn't really allow the agency to mitigate any sort of environmental impact. So the court in that case said the project should have been treated as essentially exempt from CEQA review. So I could certainly see that argument being made with certain types of housing projects, but as a matter of law, ignoring the statutory exemptions, housing development projects are still subject to CEQA, even if they don't have a general plan or a zone change.
Thank you, Tyson. All right, that's the only one I see in the Q&A. Any others before we wrap up here?
And I'd like to offer an additional note while we're waiting for any potential questions. When we are talking about the exceptions to the exemptions, and then this would be exceptions to the categorical exemptions, Margaret talked about the findings about a lack of unusual circumstances or the potential environmental impacts. And normally, once the public agency is shown the categorical exemption is appropriate, normally the burden falls on petitioners to prove the exceptions to the exemptions. But we've seen at least one court case from 2017 assert that if the public agency did not adopt findings of a lack of unusual circumstances, that the court would presume unusual circumstances existed. So I think it's best practices to, if you're going to adopt a categorical exemption, expressly find that there are no unusual circumstances and not a reasonable possibility of significant environmental impacts, or you run the risk of some trial court or court of appeal relying upon that dicta of just assuming the existence of unusual circumstances. I think that's wrong as a matter of law. The Supreme Court has said that it is petitioner's burden to demonstrate a lack of unusual circumstances. Nevertheless, that case is out there and petitioners routinely rely upon it.
Well, you make a good point, Tyson, and I'd take it back one. I think it's also important to put in writing why your exemption applies. So not just why the exceptions to the exemptions don't apply, but what's the fit for the exemption itself. So often I see that it's just a conclusory statement on a staff report, and we've got court cases that say, oh, you don't need to make findings related to that. But better practice, and better practice for some courts, is to actually have the finding and the evidence to back up that finding.
And I will say, again, circling back to whether CEQA is or is not applicable, I know some public agencies have been requiring CEQA review for some types of housing projects, and some YIMBYs, the Yes in My Backyard, have been asserting that the public agencies are kind of dragging their feet with the CEQA process. So there is, I think, a pending CEQA bill out there about abuse of the CEQA process for housing types of projects. But again, that's still a pending bill and not approved. And
one last final PS, Curtis made a very important point when working with exemptions. We're always much happier if you file a notice of exemption to start the statute of limitations running. It's also recommended that you list your CEQA action on your agenda for purposes of the Brown Act, so that folks that are going to object have to object if in fact it's before a hearing at that time, and that requires that they then exhaust their administrative remedies. In other words, they make their arguments at that meeting. If you don't lay it all out, then you lose that opportunity as a lead agency to rely on exhaustion.
Thank you, Margaret. Okay, we did have one other question come up here. What level of detail do you recommend for CEQA practitioners when cities request a memorandum to show that a project is consistent with a general plan? For example, the latest housing element update EIR. And I can take a first pass at this, but certainly like to hear others' thoughts. We recently actually prepared a CEQA memo using 15183 of the guidelines, which we'll talk about more in the next webinar, for projects that are consistent with a general plan. And the way we did it, we used an environmental checklist and went through each of them as kind of a modified checklist to identify what the previous conclusions were, whether the project results in any new significant impacts or more severe significant impacts, or if it's within the scope of what was already addressed, and then made a conclusion as to whether or not it was within the scope or if there were any new impacts. And I think at least that's how we did it in a project recently. I don't know if you others have thoughts on that.
Well, I have a corollary thought. One of the questions I frequently get is, well, when we're doing a consistency analysis, how deep a dive is it? What do we compare the project to? And certainly at a minimum, you want to be looking at your land use designations, your land use map, and your goals and policies and objectives. And we do have, several court cases that remind us that consistency determinations by the lead agency is what counts. And we give a lot of deference to those lead agencies. And then I lay it out. I mean, this is a typical section in an EIR too. When I'm looking for consistency of the general plan, I want to explain whether there's any inconsistencies as that guideline language is used.
And along those lines, Margaret, I do think it's important if there's something that's quantitatively inconsistent, you have a policy that says no more than 5 stories and your project is 6 stories. I think it's important to acknowledge that at least policy inconsistency, but that may not require a finding that you're inconsistent with the plan as a whole. And that's one area where if you address that at the approval stage, I think you're better suited at the litigation stage if someone raises that argument of, we acknowledge that there was that minor inconsistency, but we still believe that it furthers the general plan as a whole and is therefore consistent with the general plan as a whole. And I think there's always the issue of, I think the case was Endangered Habitats League from around 10 years ago, where the court said basically, if you have an inconsistency with an individual policy that's mandatory, then that requires an inconsistency finding. But what is or is not mandatory is really ultimately a question of discretion to the public agency. But I think you need to acknowledge if there is an inconsistency and adopt a finding as to whether that is or is not a mandatory policy that can essentially be overridden or at least viewed as a whole for the general plan consistency finding.
Well, in the context of, I was just going to say, in the context of CEQA, I usually like to take that a step further and identify whether that inconsistency results in a physical environmental effect. Too,
Absolutely.
Right. And as additional practice pointers for determining if the project is consistent with the general plan EIR, in other words, it's covered by that EIR, using the checklist that you refer to, Chad, I think is a practical matter. It can be, checklist answers and a couple to few paragraphs of explaining why that consistency is occurring, and then a reference by page number to the general plan EIR, so that anybody that wants to track it back to the EIR can easily do that. So a couple of just practical pointers in how to do that in a checklist form, consistency with the EIR versus the general plan.
But from a pure CEQA perspective, or at least from an EIR perspective, you're only required to disclose inconsistencies under 15125D of the CEQA guidelines. So if your project is consistent, then technically no analysis is required, but most of the attorneys don't like to rely upon that type of reasoning.
Yeah, and Tyson, I was alluding to the fact that the question had EIR stuck at the end, so thinking about
yes,
EIR, not just related to the general plan policies.
Okay, well, that's the end of the questions we have here, but feel free to, if you have additional questions, email Nasha at the email address here. You can also keep an eye out for any updates on SCAG's website, where this particular presentation and the recordings will be posted here shortly. So I think with that, we'll go ahead and adjourn and say thank you.
Thank you, everybody.
Thank you all.
Appreciate it. Bye.